Next, picking up on the copyright topic and also the European regulations that derive from the digital single market is Ben White from Bournemouth University. He's a researcher at the Centre of Intellectual Property Policy and Management. Ben, thank you very much for joining us. Benjamin, this is your, over to you now.
Can I just check that you can, it looks like you can see and hear me okay. Yep. Yes, no. Right, I'm assuming that people can hear me, so I will just carry on. So thank you very much to the Estonian National Library for inviting me to speak today. I'm actually in Tokyo at the moment at a Japanese university here doing some AI and intellectual property law related research. So as mentioned earlier on, the new Digital Single Market Directive, which was passed in 2019, should have been implemented across member state law by June 7th, 2021. But at the moment, only a very small number of countries due to Corona have actually implemented the directive. And the directive is interesting because it includes not only one, but actually two limitations and exceptions to provisions which allow what the directive refers to as text and data mining. We've heard the term AI today. I personally don't particularly like the term AI because it isn't really intelligent and I'm not sure it's, so we're a million miles away from artificial intelligence. So I actually prefer the term machine learning. So just as a quick recap, as I'm sure everybody knows, what we're talking about here is the analysis of data, increasingly large amounts of data, which are then synthesized using now computers. You could, of course, do text and data mining and analysis with a pen and paper, but we're really talking about computers now. So what the computers are doing is analyzing data and making essentially predictions from that data. So, and because of this, we can discover new knowledge. Lots of examples here, but I think this is a particularly fascinating one from the UK, where some people, some data collectors were employed, and they went through paper PhD theses. And as a result of that, they found 50% of all the molecules that they found in the PhD theses were not recorded in existing molecular databases. So all this information sitting across lots of PhDs, which is essentially not dead to anyone who doesn't physically enter the library and read those PhDs. So, there's lots of new information that can be discovered by computers. So I think when we hear the term AI, it often seems to me that probably what people are talking about most often are neural networks. And I just wanted to make it clear that there are many different types of machine learning programs. So this is a little machine algorithm cheat sheet. So depending on what type of learning you're doing and depending what your particular issues are, it recommends, as you can see, different sorts of AI, different sorts of machine learnings. So quite simple software like decision trees and logistic regression, random forests, again, multiple decision trees essentially, neural networks, SVM models, I'm sure, are here. So there isn't one type of AI, one type of machine learning. There are many, many different programs. And some are quite simple, historical, like logistic regression. And and therefore are very explainable, very transparent, very easy to understand, going through to more complex machine learning models like neural networks. So I just wanted to sort of, AI is this sort of mysterious marketing term that a lot of people use. But in reality, there are many different technologies, and some are quite simple and some are less simple. So what I'm really going to focus on today is the Digital Single Market Directive. And I'm also going to critique it slightly. And then at the end of the presentation, if there's time, and please intervene if I'm running over, I'll talk a little bit about what we see in Japan and what we see in the US, because I think the European approach is essentially rather disappointing. Not less so, I think, for cultural heritage institutions and universities. I think it's very good there, but certainly for businesses, and businesses, of course, are the main users of machine learning. We've ended up with a very poor copyright-based solution, which will ensure that Europe is not a great place, I think, to do machine learning if you're a business. So we've got two exceptions, two provisions. One is aimed at research organizations, cultural heritage organizations, and people associated with them. You must have legal access to the content. So if you suspect the material to be illegal, and you don't have lawful access, then you cannot do the analysis on that material. No money is payable to rights holders for this. And I think very, very importantly, if the contract prevents data analytics, machine learning, you can ignore the contract. The exception, this new provision in law, once it's transposed into your country, will allow you to, under this article, do text and data mining if you're in a research organization or a cultural heritage organization. You don't need to worry about what the contract says. And rather interestingly, this is rather a gray area. I don't know if it's an oversight or quite what, there isn't an explicit exclusion in the directive for the Computer Programs Directive. So it kind of raises the question, does that mean that you can't do data analytics on other software? And I think if the answer might be that you still can, or the answer might be that you can't. So there's a question mark certainly about data analytics and machine learning, where what you are analyzing is software. It requires some form of stakeholder dialogue, which will be convened by the government, where universities and cultural heritage organizations have to sort of discuss primarily, I think, storage of the data. So the directive makes it quite clear that you can keep the data that you're analyzing, the copyright data that you're analyzing, for as long as you want. But the directive talks about trusted intermediaries and keeping the third-party data, the in-copyright material, the material that's subject to database rights, within an appropriate level of security. And I think it's really important that in any such dialogue, it's made very, very clear that universities, cultural heritage organizations are trusted intermediaries. There is no requirement for data to be held by a third party. And on the contrary, any such requirements would undermine your ability to do research, as well as if you look at a lot of the requirements by funders, it will actually undermine and conflict with the requirements that funders put on any funding that they've given for data analytics purposes. So hopefully, when it's transposed into, or if it has been already, if you're in Germany and the Netherlands, for example, it will have been recognized that universities, cultural heritage organizations, research organizations are trusted intermediaries. No requirement for material to be stored elsewhere. Technical protection measures in kind of natural language, often called DRMs, digital rights management systems. These are technical technologies which essentially stop you from being able to copy a digital work. So, for example, capture technology is a sort of technical protection measure. The directive does not allow technical protection measures from preventing your right, and I would assert it's a right under Article 3 to do data mining, AI, machine learning using in-copyright material. And as part of stakeholder dialogue, or even if there isn't stakeholder dialogue, I think the issue that we face in most European countries is that if you cannot do the data mining because of a technical protection measure, you then have to go to government to say, I need access to this material, give me access to this material. So then the government will have to contact the rights holder, and often in nearly all, the vast majority of member states, it's really unclear what this process is. Who do you approach? How long will it take? So I think as part of transposition, in order that your university's research organizations' abilities are not to do machine learning are not undermined by technical protection measures, I think it's really important to get a very clear understanding, hopefully a commitment in law. Actually, how long does this process take? How long will it take? What are the response times? You know, I would say that government should sort this out within 72 hours. A lot of money is going into doing machine learning, and if you can't access this material that you have a right to access, then, you know, I think you could make a case that compensation, you know, should be forthcoming as well. So I think it's really important that research organizations, cultural heritage organizations are very strong on this to say TPMs should not stop AI and machine learning. If they do, this needs to be solved very, very quickly by the government. As a colleague said, you know, you get compensated if your train is late. Well, you know, perhaps if your data train is late, you should be compensated at all because of all the upstream investment that you're putting into the processes. And then it's stopped because there's some technical protection measure preventing access. The directive allows, I would argue, digitization for data mining purposes, so you can digitize analog material. What it doesn't do is it doesn't make clear if you have digitized material, whether you can have remote access and do the data mining remotely, or whether you actually have to go into the building where you've digitized the analog material. So it's silent on that. And again, I think it would be very important to get some kind of steer from governments. You know, if we are digitizing, I don't know, newspapers from 1900 to 1950, in order to do data mining, we do not want our data engineers to have to physically come in to the library where the paper copies sit in order to do the data analytics. You know, if remote access for digitized materials should be possible, and I think it's quite important that people, again, voice this need to government when implementing the law. So how do you've done your data mining, how do you then share the results? Well, obviously, if the result is yes or no, or the result is 23%, then there's no copyright. You can share the result. Maybe you can use the quotation exception, or maybe the illustration for teaching exception that exists in member states. So, or as we see in Germany, for example, the law makes it quite clear that you can share the results of the data mining, even if it includes copyright material of third parties. So kind of how do you share results is silent in the directive, and a bit of a problem, I think, that needs sorting, certainly at the member state level. So we also have the second Article 4, which is aimed at businesses in the main. Anyone can benefit from this. You must have legal access. And probably it is not subject to remuneration. The recitals are a bit confusing, but I think it's very unlikely that the intent was that this should be remunerated. So if there's any discussion in your country that this is subject to remuneration, I would again push back very strongly. So outputs can be kept as long as necessary. So I think that's fine. You've invested in the machine learning. You should be able to keep the databases and the results and the data sets that you've used in order to do the machine learning. And I think the wording allows that. So the downside of this exception is that rights holders can prevent people's right to enjoy this exception via contract. However, this should be made clear in machine readable means, i.e. that you don't have to go and read every single set of terms and conditions and contracts in order to understand whether access is permissible or not for data mining. So they should make any prohibitions on data mining clear using machine readable means. And again, theoretically, you can appeal if technical protection measures are preventing data mining, but if they are preventing data mining, I would imagine that often it's because they don't want you to do the data mining. So there might be no point in appealing to the government using the appeals mechanism. So again, it would appear that under this exception, you can digitize material and then undertake machine learning on it. However, it's, again, as with the previous exception, it's unclear whether data miners and machine learning engineers will physically have to visit, presumably, the library, i.e. the same place where the paper collections are held. And again, it's exactly the same with sharing results as Article 3. You can share if there's no copyright in the material, and perhaps you could use the quotation exceptions, but there's a huge, I think, question mark over the sharing, other than in a few member states like Germany that have made it clear that the results can be shared. So as you can see, there are some good bits and some bad bits. I think the research exception is very good. Essentially, as long as you've got lawful access, then technical protection measures cannot stop machine learning, and neither can contracts. You know, we have the issue, how long will it take to resolve if technical protection measures are preventing access? but at least you are essentially given the right to do machine learning if you're a research organization, cultural heritage organization, or educational establishment. The Article 4, which is aimed at businesses, is extremely poor in my opinion, because unlike other jurisdictions, it allows rights holders to say, no, you cannot analyze the material that we have copyright in. So I don't know how much longer I've got, but I'm guessing somebody, if I'm terribly running over, someone's going to jump in and say stop. Just quickly, I will just compare and contrast with a few other major jurisdictions. So we hear a lot about China. I mean, China with its, I don't know, huge population is very inward focused in terms of its machine learning and AI driven businesses. Japan and the US are far more export, digital trade focused, let's say. US, of course, one thinks immediately of the likes of Google, Amazon, Facebook, et cetera, So in the social media space, plus the logistics space with Amazon, Apple, multiple different markets, very export oriented. And Japan is a leader in robotics and driverless cars. So Japan is the only country in the world that has licensed driverless cars, which are at the eyes-off level, so level 3. So I understand in the US, they have hands-free driving license to drive on the roads, but Japan is the only country that allows eyes-off driving. So essentially, you don't have to keep your eye on the road, you just can't fall asleep. So these two countries are kind of quite interesting in terms of copyright limitations and exceptions. The US has fair use, which I'm sure many of you have heard of, which is a test. And Japan has introduced a flexible exception. So I won't go into the details. So this is the US fair use provision, which basically sets a test whether you can use an in-copyright work. And it's at least a four-pronged test. This is not exclusive. As you can see, the word includes, so it's not exclusive. The character of the work, the nature of the copyright work, the amounts used, and the effect that will have on the marketplace. So that's the test, whether you can use an in-copyright work or not. And there's a number of landmark cases in the States. I suppose the most famous is the Google Books case, so American authors versus Google, and the courts ruled categorically that data analytics, machine learning on copyright works is fair use. Nice and simple. So case law in the US, you can do data mining. We don't have this very prescriptive, very tight exception that we see in Europe. So this is the Japanese flexible exception. So it's not an open norm. And what they've done, which I think is very, very clever, is they've basically said the purpose of copyright works, books, films, paintings, et cetera, is to enjoy intellectually or sensually enjoy the work. And there are many uses of copyright works, like data analytics, for example, that do not involve enjoyment of the copyright work. You know, the machines are not reading the data and interpreting the data to make predictions and look for trends and linkages. You know, no one's enjoying that. So this is essentially, it is caught by copyright because it involves copying, but the purpose of copyright, the Japanese legislator has decided, is enjoyment. And this isn't about enjoyment. So it's created this non-exhaustive, flexible exception that basically says if you're not enjoying the work, then you can use it. So this is the last slide. So this is my quick kind of compare and contrast of the different laws. So Article 3 is, I would say, probably the best, other than question marks that you have around sharing. And interestingly, in Japan and the US, you don't need for the work that you're analyzing to have been lawfully acquired. So you can use material to do data analytics that you suspect you're using unlawfully. You definitely can share the results in terms of Japanese law. Perhaps, I think it's less clear in US law. So this is my sort of, I won't go into the details because it'll take another kind of 5 to 10 minutes to run through it, but this is my compare and contrast. And I think the conclusion is that there are pros and cons. I think the EU has definitely done a very, very poor job in supporting EU-based businesses to do data analytics. US, Japan provisions far more flexible, far more supportive of business. I think the research organization and cultural heritage focused machine learning provisions, because they don't allow technical protection measures and contracts to override the exception, perhaps are the best, other than the silence on whether you can share the data, which, as I said, certain jurisdictions have made very clear. So, so I think Brussels has done a pretty good job on Article 3. I think basically, if you want to do machine learning as a business, you are unlikely to want to stay in Europe, which I think is a bit of a shame. So that's it. I don't know what we're going to do with questions, but I will stop sharing, and then I will see chat.
Thank you, Benjamin, for this really detailed insight into the legal act of different countries. Now, in the AI domain, of course, there's been always a comparison often of the Chinese situation, the US and the EU, with China with almost no restrictions or regulations about what data can be fed into machine learning algorithms. US legal system sort of typically in favor of a company or an enterprise being in the center of protection, whereas in the EU we're always protecting the citizen or the consumer in the focus of this. Do you think that in the sort of AI perspective of things, the directive that you have just analyzed for us, is that really helping the European companies to, I don't know, leapfrog the other countries in the AI domain, or is there another sort of more fundamental legal reform required to help us gain or catch up at least with the other countries? Sorry, this is a bit general, but
yeah, I unfortunately, I think, as I said, it's done a very, well, not unfortunately, sorry, restart. I think the Commission's done, and the Parliament, of course, has done a really, really good job on supporting universities and research organisations using the slang of British youth. I think it's done an epic fail on supporting European-based businesses. I really think that this needs to be rethought. To me, it's unbelievable that the Commission has not sought to support European businesses in AI in regards to in copyright material, which is essentially material on the web. which is the largest single database that's used, the Commission has not supported EU-based businesses. And it's extraordinary. You know, we've got the AI regulation, which is doing some very, very good things. Again, I think you can perhaps criticize that for maybe over-regulating. I think it's a very difficult area. Previous speaker spoke about the AI regulation draft. I'm wondering if some of the obligations, again, will, on transparency, for example, are going to undermine smaller businesses and to the favor of the incumbents. And the incumbents in Europe are not European companies, they're American companies. So that's a very long-winded response to say they could have done much, much better to support businesses in Europe, and they failed.
Okay, we have a question that's come in via Slido, and it's asking whether writers could give a permission for linguistic data mining, maybe leaving aside the creative or mining for creative writing. But so is there a way how we can sort of take it away from memory institutions and go back to the authors or writers of texts and seek permission from them?
Well, I guess that's really what the directive has decided on already. The directive has decided if you're a research organisation, a university cultural heritage organisation, you don't need anyone's permission. And the theory behind that from a copyright perspective is that the expression, which is what copyright is there to protect, the creative expression is not what machines are interested in. The machines are analyzing the data to make predictions. And so that's kind of the grounds of this, that copyright is there to protect creative expression. This is just processing data. So research organizations don't need authors' permission. That's decided. If you're a business, then the rights holders can decide to withhold their permission for you to do mining. So, I mean, so yes, an organization is free if you're a business to decide whether you can do machine learning on that data or not, but not if you're a research organization or university.
It still sounds like we might need an update to the sort of license package that we typically ask from authors or publishers that right now includes all sorts of publishing or making public varieties, but text mining is typically still not included in that. So I think we need to also as a community enhance and develop our licensing policy. I very much like the concept of enjoying the process of mining something. Famously, Garry Kasparov, when he lost the chess match to the AI, said at least he didn't, or it didn't enjoy it. That may be a kind of deciding factor here, and maybe that's something that we could bring into discerning how the humans are reading and how the machine is reading. Have you come across anywhere regulation already on the works that have been created by AI solutions or have been written by AI? Do we have any regulation going in that direction as well?
So this is amongst academics and also consultations from member state governments and the World Intellectual Property Organization. There's a lot of people that have been writing from copyright, let's say, plus patents perspective on the outputs of AI. And now, actually, that kind of, certainly within academic circles, that dates back something like 20 years. So it's not a new topic at all, but we're a million miles away from intelligent machines. So I think it's a terrible, terrible red herring that none of us need to worry about at the moment, because there are no intelligent artificial machines making creative works. It's all human beings making decisions that the machines then follow.
Mm-hmm. Yeah, we have a question here that asks, could an artist train a machine learning tool on images with copyrighted materials like paintings or photos to generate new images for art projects?
Absolutely, and that's happening a lot. There's a funny case in, I can't remember, is it Australia or America, where they did these on these funny like furry animals, and one of the furry animals that the machine produced and was used by the company resembled one of the inputs. So yes, artists are doing this a lot, but again, the point here is don't believe the hype. It's the artist that's doing this, and the machine is just following the instructions, which might be do this, do that, or the instructions might be select at random, or the instructions might be, select at random the ears, select at random the nose. But it's the human beings that are making the decisions. So do not believe the hype when you hear the hype. We are a million miles away from artificial intelligence. All of what we're seeing is essentially predictions, or predictions or random selections.
Yeah. In any case, AI here is in the position of sort of work for hire rather than the actual author or creator that has, let's say, agency over the outcome.
Yes, there's lots of academic articles. Is it work for hire? Is it the author? Is it nobody? Is it... don't worry, we don't need to worry about this for another 100 years, is my answer.
Okay, thank you, Benjamin, for this conversation.